how the industry polices itself. And I think Professor Kakari and others spent a lot of time talking about it. But the first concern I want to raise has to do with the growing trend of influencers. We are seeing people becoming celebrities overnight, and they have numbers. You know, some of them have more following than the traditional media houses. And we saw in the build-up to the election that a lot of the politicians were sending their content to the bloggers and to the influencers. Now, the danger with that is that a lot of these bloggers and influencers don't have a mechanism of fact-checking and, you know, establishing the appropriateness of the content that they are getting. A lot of them are looking for the money, and so they get the content and they put it out there. How do we reimagine a situation where we bring all these bloggers and influencers under one umbrella, where they get some guidance on how to, you know, work closely with the traditional media organizations, and also how to, you know, fact check some of the things that they are getting before they put it out there? Because at the end of the day, if they issues around misinformation and disinformation, so I think it is in our interest to find a way that that sort of collaboration would take place. Then secondly is the issue about watershed. We know that within the broadcasting space, we have what we call the watershed period, which is the time that certain programs are supposed to take place so that we don't expose children and minors to adult content. But what I have also seen is that these programs take place late at night, but in the morning, they are all over social media and they are being shared. So what is happening is that because people stream the programs at night, they leave the recording and it is everywhere and it is being circulated on various social media platforms, and a lot of young people who are not supposed to have access to these content are being exposed to them. So how do we find a way to also deal with that? Then I also agree with the suggestion by the Director General for the Ghana Broadcasting Corporation that we need to have a lot more radio stations. And I realized that Mr. Suleiman Abrahima said, well, you can make the argument about the language because there are a number of radio stations, but we should also be interested in exactly what the other radio stations that he talked about are doing. Because if the idea is not public service, then it becomes problematic. Because now there is a lot of fascination about fighting this and misinformation online. And there is a lot that is falling through the cracks offline. And it is these radio stations that are holding the fort admirably. So being able to, you know, properly position the state broadcaster to be able to make sure that access to radio is, you know, is enhanced, I think it's very important. Then the final one I would want to talk about is it's also the issue about content. So for instance, you have a major newspaper capturing or doing coverage about a story involving two politicians in a sex scandal. Then they capture the politician in a suit. Then they look for the female politician in a casual outfit, you know, and already putting the woman in a certain light, and nobody talks about it. We have all these radio stations in the Ashanti region that are, you know, have programs meant to tackle domestic violence and abuse. And they bring sexual assault survivors and victims to their studios, and they are asking them very salacious, you know, details about how their abusers undress them, the sex positions, and they are making fun of it. And these videos are being circulated all over the place, and people are laughing, you know, instead of about. And now that I don't know who to direct these concerns to. So I think these are some of the issues that I think we can, you know, think around and see how exactly we can get the Constitution to address those. Thank you.
Thank you. My name is George Chumesi, and I am um, an entrepreneur in the media space, basically focusing on digital media and also the academics in terms of research and development. And my background, just for context, is that I'm a I work or I'm a fellow with the Shorenstein Center at Harvard, and have had access to um, the process of the evolving American landscape and how that, in relation to this conversation, may apply. So, from a constitutional framework, I've heard a lot of very positive things said, but I think the framing, perhaps public service broadcasting, is not relevant anymore. It's public interest media. And public interest media takes into account the new technologies. The concept of public interest therefore becomes public good. That's number one. The second is to do with the law. The law, in terms of how, from a constitutional framework or framing perspective, media is addressed. Media, in terms of public interest, has two facets right now. It's got the digital governance matrix, and then it's got the network society. The network society has fundamentally taken over all forms of old traditional media in terms of how content is distributed, the infrastructure that drives content, and more importantly, how it's funded. I think in framing this new constitutional ethos that you're considering, perhaps you should see Ghana as potentially the bridgehead for example, Prof. Kakari, you bear me out on this. Take, for example, the Ghana Broadcasting Corporation. The problems that it has are the same problems that the South African Broadcasting Corporation has. The same problem that NTA has in Nigeria, and the same problem KBC has. So fundamentally, the model in terms of how the colonial system worked and how media was passed on does not work. When you look at Graphic Corporation, Times Corporation, they are not breaking even without subsidy. So reframing the constitutional ethos that you are considering, what we must take into consideration is that our forefathers, for a reason, made sure that the Constitution would protect media. And that's what you refer to, say, as the fourth estate. So the reason for media is to develop the mind, to break down barriers, and to create cultural sensitivity. So when you look at, for example, the Africa Continental Free Trade Agreement, it's not going to work without public interest media. So Ghana's role has to be perceived from what you're doing as a public interest ecosystem which leads the continent. Like, you've got the Africa Continental Free Trade Agreement, you've got the AFDB, you've got Afri-Exim Bank. You need a system, we need a system which looks at media in terms of public goods. So a lot of the issues that have been raised here, when you look at what a network society definition is, it's simply infrastructure. Everything from undersea cables to domain names, things like root services, service and all of that. They look at the economics and societal layer. It looks at users, education, apps, social media, what misinformation and all of that. So we've got to look at it holistically. The final point I want to make is Professor Amin said the government should consider naming Ghana as the 2015 7th June deadline. The guys in Switzerland set up, forgotten their name, but it's like the body. ITU set up. The reality is that it's not true. You need a digital media ecosystem in order to say that your country is digitally savvy. We don't have that. The opportunity, however, is that according to Google and IFC, the industry this year, nobody has tapped it, but if we had tapped it, it would be 180 billion US dollars this year. The report is public domain, so there's money to be made. All this thing about funding and public fund, the government hasn't got the resource to fund anything to do with media. But if you look at media and public good, as a commercial opportunity, as Professor said, and public good within the context of taxing the commercial opportunity, then you have a framework which works for Africa, which works for Ghana. And if it's done well, based on the if digital media is properly applied, it would make far more money than cocoa and gold in Ghana. Thank you.
Thank you. Is it also possible to share these insights in digestible form for people like us, so that we can have your insights in a submission, a memo for the commission?
Yeah, I've got a lot. If I get an email address, I'll be happy to send you data.
Good, thank you. We'll stay with the left for a little bit. You are closer. Let me hear.
Thank you very much, Mr. Chairman. My name is Jerome Kuse.
Jerome, it seems you've gone ahead to reiterate the point that Prof there had raised, Ibrahim Tanko, on the vagueness of some of the wordings that, for those who don't know me, my name is Kemini. I work for Media General. The vagueness of some of the wordings that impede our ability to get information. I can't begin to count how many times the excuse of national security, the excuse of public, and in fact, in the wordings, we have public morality as well. Who is determining all that? So it's important that there is clarity on those things. And we have examples to back that. The Public Order Act. There was a lot of times prior to very recent history that the police determined whether or not people should demonstrate. Public pushback, legal pushback taught us that indeed they had to even go to court to make a case for why or why not, you can demonstrate. I think it's the same issue that Ibrahim Tanko is raising, and it's really important for us from a practitioner's point of view. I go to the point on definitions. When we look at the phrasings on media freedom, on what we are able to do and what we are not able to do, there is no clarity on whether the press and media is referring to corporate bodies or individual journalists. And in fact, if you look through, it's only at, I think, 171 that the issue of journalists is raised. And so it's important that we redefine, press, media, individuals, so that the focus then is on public, instead of just, something being said. The focus is on publication. So everybody now falls within the net. It's just those of us who have gone to school and trained as journalists or trained on the job as journalists. Then I would dovetail into regulation, because there's been a lot of calls, let's regulate, let's regulate. Now, when we begin to see the issue from publication point of view, rather than a journalist point of view, or the news media point of view, or social media point of view, and realize that with the current system that we operate, where I can go to, even without being a journalist, I can go to social media and put something up there, and someone else will consume it, we will all become responsible. Then we'll start to see that the issue about regulation will not only be about what the journalist should come and say, but for you too, you as the person, you will start to think about some of these things. So I think the focus should, when discussing and wanting to rewrite those aspects of the law, the focus should be on publication. It should be all, which is more important, in my opinion, so to speak. That way, we are also able to bring in our friends from new media, because as we have, as we have admitted, we do not have any provisions for our social media friends. I believe it will deal with that. So that's it on definitions on press and media. I also want to say that it's important that we tread cautiously when we call for regulation. I understand the need to keep the airwaves sane, but we also need to work in such a way that we don't have freedom of speech. And again, I'd want you to note that I didn't put it just at the doorstep of the journalist, Because at the end of the day, so that you are able to do. Now, when we begin to say that let's regulate, then what happens to my mother at home? We should start to ask ourselves that question. So let's broaden it. And again, in my opinion, you would see that when we talk about regulating, it will lead us down the right path. Indeed, that's what I'd like to say on regulation as well. The issue of licensing, which the chairperson raised, I don't think has been properly dealt with. The Constitution is clear, and I think that, Prof, you read something from 1623. The complete of that has to do with the licensing, and I don't think that when you ask the question as to whether or not that provision in the Constitution had outlived its usefulness, I don't think we were able to get to the bottom of that. So, I mean, for those of us who have the legal brains, perhaps we could do that. Because again, like led Rekubrobe to establish Radio I. And in fact, in very recent history, we have seen him also make the point that media houses do not need licenses to operate in this country, especially on the back of some media houses that were closed because their licenses had expired. So I think it's important that we look at that as well. The D also look at Article 169, which is on the appointment of editors, because editors are supposed to be gatekeepers in a commission. It would seem as though it was a cock and cap measure that had been put there, because if I cannot rise through the ranks and become an editor in state media or in public media, and my appointment needs to be determined, intuitive, outcome. Because then where is the independence of that? People should be able to rise and become ends of the state or public media as we're talking about it. So I think basically those are the things I want to outline at this time. Thank you.
Thank you very much, Mr. Chairman. My name is Jerome Kuse. For the past 12 years, I've been running a public interest finance and economics blog. I want to say a few words for social media because I believe today's engagement is about the media and the social media. What I want to say is that I believe social media has an internal mechanism for regulation. I know sometimes we may think that social media is the worst purveyor of false news and making stuff up. But the thing about social media is that whatever you post has an immediate reaction which people see. So you put something out, people can comment, people can call you out, and all of that is available to the public. And that is something that traditional media does not necessarily have. So even if we believe that social media people are, let's say, a bit careless in what they put out, the system allows some kind of self-regulation and fact-checking. And now with artificial intelligence, people are able to ask third-party applications to verify what somebody has put out there. So we shouldn't paint social media as this wild platform, this unregulated space, as compared to traditional media, because I'm willing it's on par, if not better than traditional media in terms of self-correcting and regulating itself in terms of the information we put out there. The second thing I want to say is that I believe we need to start looking at digital assets and making it part of state assets. I'll give you an example. If there should be a system in place that ensures that this handle is consistent across all governments, that there is a proper procedure through which these assets are kept and these assets are transferred from one government to the other. And this is a very critical step towards checking false information. Recently, the account of the president was hacked, and some cryptocurrency whatever was put on it. I believe that it's important that we consider these accounts as state assets and put in some kind of mechanism to not only protect them, but ensure that the information on there can be archived. The information there, the details of the accounts can be transferred from one government to the other. And so when people are looking for direct, verified information, we all know the handle which we should go for. We all know the handle that we should go out to look for that information from. The next thing I want to talk about is the fact checking. Already, people are using third-party fact checkers. And I believe that as part of public or state media, we should fund fact-checking organizations. In fact, there should be an official one if possible. For example, you argue with somebody these days. I was having an argument with somebody, and the person went to bring me information from ChatGPT to say that what I was saying was wrong. And ChatGPT is essentially the independent arbiter. But that is not the case. That is also an opinion. So I believe that it's important the state resources fact-checking institutions or have an official fact-checking institution as part of the public interest media that it is carrying out. My last submission, it doesn't have to do with social media, but it has to do with young people in general. I overheard, I'm not a lawyer, but I overheard the thing about some institutions that are described in the Constitution, not necessarily named. And I was asking my lawyer friend whether there's any association of students that is named in the Constitution. So if there's an association of marketers, is there an association of students? And coming from someone who was very active in student politics, it has been sad to see how weak the student front has become. So I want to suggest, is there a way we can have association of students in the Constitution so that the state would take an active interest in preserving the student front as an independent functions are required? That's my contribution. Thank you.
Thank you. I think we can go back to the right, and then we'll come back. Oh, really? She was her lady is speaking for the lady. So, okay. So, please.
Thank you, Mr. Chair. Good afternoon, everyone. My name is Gloria, and I work with the Ghana Independent Broadcasters Association. I felt much had been said about regulations and what would lack thereof or need for licensing in the media industry. I felt I should say something. The role of the NCA, as also advised by the International Telecommunications Commission, is to the country. And so by their role, by what they do, so long as the frequency is being used, these frequencies that are in use are not only being used by broadcasters, but the airlines use them, the marines use modalities on how to manage these resources. And so for us, the broadcasters, and the NMC and the NCA, because the NCA law in itself already says that they should be working with the NMC. So why don't they then come together to regulate that broadcasting space where the authorizations will be given? Okay, that is our submission. And I believe we already presented something, but as I was speaking to Prof a little earlier on, I promised sending him more material so that he could study to see whether it was relevant to the work you were doing. Because a lot of submissions have been made, and the media, we've come together to work on all these things. That is the GJA, the printers, private publishers, and online Publishers Association of Ghana, and GIBA. We've been coming together to work. At a point, we also work with the Media Foundation for West Africa. So it's whatever position we present, It's unified position, sort of. So thank you, Mr. Chair.
Thank you very much. It's good to hear that you have already presented something, but you intend to augment it even
Right.
further.
Thank you very much, Mr. Chair. A couple of things just for the preliminary issues, just like Jerome raised about
Reintroduction.
Okay, yeah. My name is Kwiku Asante. I work at Joy FM and Joy News. So Jerome is of the opinion that we must write into the Constitution, say the student body. I think that we must take away every private association from the Constitution, because the Constitution itself provides for freedom of association. So that why is the Ghana Bar Association provided for in the Constitution? So that next 2 years, if some lawyers find themselves and found the Judicial Council, for instance. So if it is possible, we must do away with every private association, strictly speaking, from the Constitution.
Constitution membership will be constituted either only by public officers or by persons chosen in their individual capacity, no institutional representation.
I think there may be a way to do that. So that, for instance, in the Constitution, there will be places where the Constitution will say from faith-based organizations. And these faith-based organizations sometimes find ways to put themselves on some of these places, so that in certain university governing councils, in those statutes, sometimes provided for teacher unions, NAT, CCT, NAGRAT, find a workable way to put themselves on some of these boards. Because the problem with legislating onto the Constitution, the supreme law of the land, say GB, can go out there. I think that must be dealt with. And while I have the floor still, in the last few days, we have been doing a lot of reporting about whether or not there's a power or not there's a power vacuum. And a lot of mention have been made in the Supreme Court decision in Asari, where traveling out has been said to be inability to perform its function. So that yesterday, the president was signing memorandums in Ivory Coast or Togo as president of Ghana. And then if the speaker was around, the speaker is the acting president. Do we have two presidents at the same time? Especially if the court is not willing to reverse itself, perhaps the wording must be dealt with in the Constitution as a way of dealing with that. Coming into the substantives of the media conversation, I believe one of the things we can do with the National Media Commission, for instance, is to broaden a little bit of its scope. So that, for instance, when it comes to authorization in terms of the line census, you can take the frequency part from the National Committee, very little emphasis on media and the frequency authorization. We know that it become a platform for politicians to be taking it. I report from Parliament, and I know about how access to frame its powers. Instead of, say, merging it, then National Communication Authority can focus on what I believe they've actually been over-focusing on, the telcos and other business. They can focus on that. And the National Media Commission, which actually has specialization in media issues, can actually focus and deal with that. I believe that is one of the things we can do. Again, in earlier remarks that were made by one of us here, talked about whether or not the NMC must have powers to summon people and to compel attendance and all that. I'm a bit divided on that because of the current status of the NMC as a body. So that even courts where they can compel witness attendance, for instance, can you forcibly hold someone's hands and push them into a dock and ask them to do certain things? So the NMC will be able to proceed and take certain actions. It can be appealed to, say, the High Courts, for instance, so that persons who feel like the National Media Commission may not have a certain level of expertise to deal with certain issues can have a second forum that it can go to. So I believe if you do that, that would be great, the state broadcaster. Although it's usually called the state broadcaster, it appears to me to be government broadcaster. So that the focus of GBC, for instance, the Ghana Broadcasting Corporation, because of its financing model, has become a government broadcaster, because the budget of GBC, as we've come to know it now, prior to the new president striking off the information ministry, the budget went through the information ministry. So that level of political control still exists. But if you go to Germany, for instance, where the TV licensing regime really works well, or in other European countries like say, United Kingdom, if we legislate, say, into the Constitution or into other subsidiary legislation as to the TV licensing fee, then the GBC and others become proper state media. And then we can, for instance, look at the composition of the board. We can have a designation for it. Well, in Germany, for instance, they have representatives from political parties that have a certain clout in parliament, for instance. And then you can put on a lot more diverse persons, because as GBC still exists in its current frame, there's things. So I think let's do that. And then there's the bit about using false news laws to actually strangulate journalism in the country, so that in last 2 years, Bobby Ansah was picked up because he said the wife of the vice president owned this land or that. Code and other such laws are that. For instance, if I went to the stadium, that's false news, and it led to injuries, it led to death. In my opinion, that is what some of those things are supposed to deal with. Not just like the vice president owned this land, the president owned this. If it's false, I can take it on in the way without police officers going to a media house pushing someone out. The only challenge is, the Constitution, there's a big put in place some of these principles so that all other subsidiary legislation will come with that. So that in the US, the First Amendment, the 14th Amendment, these are things that have been written thousands of years, hundreds of years prior. But still, because they have a certain frame that encapsulates of very broad ideas, and the other thing follows. The other thing is that, and that's why I conclude, is that we can write very beautiful laws. The problem sometimes is the people who will implement it or the people who sit on it. Or because, the idea can be as brilliant as possible. If someone decides that they will represent the law in a certain way, it just wouldn't work. So that, for instance, and this is not a disrespectful criticism of the Supreme Court, I struggle to see how it goes back to the provision Asari case, where the president travels or is unable to perform. Because the moment you go into the next section, the next clause, it actually clarifies. It's not like where the president travels or is unable to perform his functions. Because those two things are distinguishable. You can separate them. So if you have all the brilliant laws and you have I just say, okay, I'm doing purposive interpretation, and then he'll do something else with the law, or politicians will always find a way to deal with it. The way in which the politics is done in the country also contributes some of those things. So you're doing a great work, probably come out with a report, there'll be a white paper, the process will be done, and then ultimately, we get a very beautiful law, we put it on the books, but if the implementation and the conversation around how things are implemented are not really properly done, then I guess we'll just come back here 10 years down the line, we'll say the Constitution has a problem, let's rewrite it, let's do this, let's throw it away, and then we'll find a way. And then just before I was willing to hand the mic, I just got this brief.
The last one.
Yes, this one is truly the last one.
We are done.
Okay. Oh, V-mates, if you give me just one more. V-mates.
This is no V-mates
Okay.
matter.
The Constitution, the amendments are made and how it will be implemented. We are hoping that the media will carry us forward and we help to disseminate our recommendation and then be the gatekeeper to make sure that Parliament passes the law which will let the process for, let's say, referendum take place and then pass legislation to give effect to our recommendation. So I'm glad that you've made that point. So please.
Yeah, actually, I was going to say almost, it's interesting because I was going to say that it is true. In terms of implementation, the Constitution, I think, empowers us all to help with implementation in multiple ways, right? Unlike most constitutions, we have Article 2 that allows every one of us to enforce the Constitution in court. We have to uphold the accountability of government and all of that to the people. We have a constitution that says the Supreme Court can change its mind if it makes a mistake. It can reverse itself. So there are a number of things in the Constitution that essentially admit that we may have operational difficulties here and there. But it's giving us, right? So I think it's also because we as a citizenry have essentially abdicated and oftentimes think that the operators of the Constitution are only the public officials who must, the duty bearers are the only operators of the, it's also us, actually. We, the rights holders, more than the duty bearers, are the ones who must push it. So really, even through this process, it's not just us. Once we're done, it is up to the public to follow the process, to look at the report, to mobilize around it if you support it, to say you don't like this or that. So there's a role for everybody. Abdication is one way of spoiling it. And there are so many things in the Constitution that nobody has gone to court to enforce. A lot of the complaints we are actually talking about here, many of them have never been tested in court by anybody. Even people who know that there's something going on that's not proper. Nobody has. So sometimes we say, oh, the courts are the guardians of the Constitution. Actually, all of us are the guardians of the Constitution. Because how the guardian, how can the court, that is a passive agent, sitting there for the case to be brought, the one who you have called the guardian of the Constitution? It's you. You're the one who can actually activate the Constitution before the court can take notice of it and take the matter. So we need to change the way we think about these things, and I think it's a good time for us to be rethinking some of these ideas. But there are tools there for all of us to make sure that it works. I want to refer you to Article 193 of the 79 Constitution, right? The 79 Constitution created the Press Commission, which is the precursor to see what it was in the last Constitution. Very interesting provision here. So the function of the Press Commission shall include, right, 193D, the making by constitutional instrument of regulations for, right? So between that period and now, the formulation changed, right? And now we are back talking about who licenses, who authorizes before the NCA can issue and all of that. So sometimes, I think, going back to the history, better formulation, maybe you could go back and look at it. I also noticed one thing in the 79 Constitution. You just mentioned NMC maybe summoning media, violators of whatever, offenders, and adjudicating some matter before it goes to high court. Actually, in 1979, the Press Commission had, its powers included investigation, and mediation, and settlement. Right? So they've moved away from a quasi-judicial kind of tool in the way in which we are thinking about the NMC. And maybe in thinking about rethinking again, we should go back to 79 and see if there's something there that may be useful to bring back into the conversation. Yeah.
Take off from where Kweku landed. It is true, I agree with him. We may have very beautiful laws, but the implementation or the application of the law. So we've been talking about Section 76 of the Electronic Communications Act and Section 208 of the Criminal Offences Act. They may be good, well intended, as George Sapon had alluded earlier, but the application and to clamp down on the media, sometimes to the extent of issues that are clearly defamatory, and yet journalists were arrested and imprisoned. So if we don't implement the laws as they are well intended, we will always have issues. And that is our fundamental issue against those laws. And then I also want to touch on Article 1623. I strongly believe that the framers of the Constitution had put that provision there because of our history. If you read the newspaper licensing law history, since it was first introduced in 1963 up to the PNDC era, that law had stifled the development of the media to a great extent, and Prof. Kakari alluded to that. So I want to believe that is why the provision was made, and it is even an entrenched clause. And in our conversation, I think we should appreciate that as of now, we don't have a licensing regime in our media space. So for the electronic media, what NCA does is authorization. A lot of the time, we throw in the word licensing, but NCA doesn't license. They give authorization. And if you look at what the NMC does with newspapers, once you satisfy the requirements, NMC only gives you a certificate. So it is not a license, and we are not operating under that regime. And Prof, I will vote for that provision to be maintained, because it aligns also with international best practice, that you need to have that free space. We get the regulation right, and we'll be able to address some of the ills surrounding Article 162 to appoint the chairman
So the funding service.
My friend Kamini is not comfortable with that, but I think that is better.
With the word TV license, because I mean,
provide opportunities and facilities for the
collective
presentation of diverse views and dissenting opinions.
When you know,
I am thinking that that should not be limited to the media alone.
The law to
it should be opened up to all that provision intended to promote democracy for the
public
presentation of divergent views and dissenting opinion. So
when you go public service broadcasting, you have to define what
function of the state-owned media. So just as it's
taken off the
for under 1625, the watchdog.
You are publicly funded to do broadcasting for public good and define the public good. What they do is that there are thresholds for monitoring. There's a systems of accountability.
Pull the responsibility and accountability of the
last person to just say that we just want to be funded.
Of the mass media. So likewise,
isn't there a reason why
a system of justifying our existence that has to be built into the process, so that we are properly, we can defend and justify why we are resourced.
You cannot just take one side.
Audit their processes, and they have to go to Parliament to get, I think somebody can help me, is it 2 years or 10 years, to get a mandate to renew their existence? Because you have to first prove that you've used the money well to justify your existence for the next lease of life. They also check audience survey to see whether they are satisfied with their service. So they are always trying to make themselves relevant. Unlike if you put up GBC like that, we will sleep. Put in mechanisms to ensure that we are accountable. Now, to make GBC, there's a talk about making GBC a constitutional body to make a tenure, to protect the tenure office. Yes. The last time a British politician tried to tamper with the position of the Director General of BBC was in 1952 or so. And he was so embarrassed that no politician in the UK has ever tampered with the BBC. We can learn from that. What have they put in place to ensure that it is protected so that there is no interference? That was the last time a politician tried, a prime minister tried to fire the BBC Director General. And he was so embarrassed that the opposition took it, and it's so embarrassing that no politician has ever tried. So the question is, how are they set up so that we can learn from that? Now, there was a question about, okay, so you have a mandate to do commercial broadcasting, you have a mandate to do public sector broadcasting, so why are you not making the money? I have the singular privilege of serving GBC as the longest serving DG since 1992. So that's my record. And I have a lesson, I have the lesson to share. GBC, my preference is split it into two, commercial wing and public service wing. If you work in the commercial wing, your salary structure is different.
But you don't need constitutional review to do that. I mean, isn't that a management, corporate restructuring division?
We require a review of the law. And we are also told that state, either in the Public Financial Management Act, or I have to confirm that, but what we are told is that we are not capable of doing that. We've tried it before, and we were told we can't, we should reverse it. For example,
that should be charged with presenting this plurality of views, not private media. I don't think we can impose such structure on private media. Why should media representing NDC or MPP open its pages or airwaves to the other party? Why? You know, it will not be, I don't think it will be democratically right to do that. I mean, you could also have the situation in the US, right, Prof? Because at some point, I think before Reagan, the FCC was implementing something called the Fairness Doctrine, where all media under the FCC rules, you were actually expected, I don't know if it was required, to have a diversity of views on certain shows, right? Of course, Reagan in the neoliberal revolution just came and did away with that. But the market itself forces even partisan media to try to represent the other views. Because even Fox News, right? We know Fox is a particular, leans one way, but even Fox News...
The law says we should be a transmission entity and a broadcast entity. And I remember very well that under the previous government, they came very hard and said a cabinet decision was taken that only NCA will be a transmission entity. And I told them that, as far as I checked, they haven't reviewed the law, which was put in place in 1968. And that law says that GBC is a broadcasting entity and a transmission. And until they review that law, we will not shut down. They backed off and allowed us to continue doing that. So what I'm trying to resistance from the executive arm of government, which will deny us the opportunity. But half of our channels can be set up as private TV stations. For example, we are supposed to be public service radio unique. My view is that unique should be a private radio station, separate, because we have already honored our mandate to Greater Accra as a region. So we don't need a second public service broadcasting entity. But here we are told we need some legislation to set up a private entity. But GBC, we should do that split, because I'll give you an example. In the last 4 years, I have lost very good staff. And because the private sector gave them better conditions. If they were in the private unit of GBC, we will make it difficult for the private sector to come and poach them. But all the TV stations of significance in Ghana have poached staff from GBC to do what they are doing because they are able to offer different working conditions, whilst I am tied to public service conditions, which will not help us to do business.
So you are helping to build, I have been alerted by my staff that we have to take a quick short break, come back, and then a short break, come back, have more conversation on this, and then open it up
Maybe
before
Chair,
lunch.
If I could finish my 3 points and then we'll go.
We will be back. I want you to come back because if I allow you to finish, you probably run away. So,
No.
so you stay with us. We'll just take a very short break, maybe 10 minutes,
All right.
because lunch is fairly close. And we'll come back and continue, and then we'll take a break for lunch, come back. We are billed to end today around 5.